Our speaker today is Dr. Maithili Shroff. She's a licensed manager for science and engineer at the UNHInnovation that houses the technology transfer unit of UNH. Dr. Shroff graduated with first-class honor from the University of Leicester, UK. She then moved to the Middle East, working as a research assistant and quality assurance manager. She earned her doctorate from the University of Dundee, UK. Dr. Shroff is a recipient of the prestigious Life Arc Alton Technology Transfer Fellowship and is a certified licensed professional. I hope you all guys enjoy our presentation today.
Thank you so much for the introduction. Hope you guys can hear me. And thank you for inviting me for this talk, Brian and the entire team that organized this. Really appreciate being here, and hopefully we can share in this conversation, which is ever evolving around AI and IP. So I hope to provide some guidance from our technology transfer office's perspective, which we'll try to answer some of your questions and point you to resources that you can look into otherwise. So for a brief overview of the talk, for those of you who may not necessarily be aware of us or what we do, I'll provide a quick introduction to UNHInnovation, which is the tech transfer office here at the University of New Hampshire. We'll then move on to a brief introduction of AI tools. I am not an AI expert. I work in IP all day long, but I'll aim to kind of briefly introduce the topic just for the sake of completeness. We'll then move on to the meat of the talk, which is around the use of AI tools and intellectual property and how they impact each other, and kind of close the conversation by addressing some of the challenges and opportunities that are presented by this. So to get us started, I will provide a brief introduction to tech transfer, which is at UNHInnovation. So our IP team is essentially two people right now. So we have Jenna Maithili, who's the Director of Technology Transfer and is my supervisor, and I am the licensing manager. We had a position for another licensing manager that did creative and digital works, and I was responsible for sciences and engineering. But right now, it's just the two of us. So you're looking at the two people that manage the entire IP portfolio here at UNH. But we don't do it alone. We have a lot of support from our supportive team at Tech Transfer. So we have Allison Bell, who's the Director of Marketing, Communications, and Engagement. We have Nicole Colbath, who's our business manager and handles the financial side of things. And we have our licensing admin and licensing assistant who work part-time with us to manage some of the back-end things that we do. And we could not do what we do without the support of our legal residents and volunteers. So if you or somebody you know is interested in learning more about IP and would like to volunteer at UNH, please do get in touch. So for those of you who may not be aware, tech transfer is one aspect of the things we do at UNHInnovation. We also have other units such as corporate engagement and the Entrepreneurship Center that provide different services. So please do check us out. And what's the purpose of UNHInnovation? Why does it exist? So really, we're there to advocate for and manage, to transfer UNH-derived ideas from the university or from a research base to the public to maximize their societal and economic impact. So at UNHI, what we do is we protect, promote, and manage all of UNH's innovations. We also support startup formations that are based on UNH's intellectual property, and we try to develop new opportunities for engagement with our industry partners and develop and foster collaborations in that way. So we try to find different avenues to make sure that the research from university gets out of the university for societal good. right? So when I talk about IP and intellectual property, so I'll be using the shorthand IP quite often during this talk. What are we talking about in terms of protection? So any kind of intellectual property can be eligible for different types of protection, right? So you have patent protection, which is eligible for any kind of invention and concept. So a machine, method, device, a particular type of design, all of those things fall under patent protection. We also have trademarks or service marks that are used to identify goods or services from a particular company or organization. You can have copyright protection, which is present to protect creative expressions. And I'll go through them a little bit when we talk about them in the context of AI. We generally don't do this at the university, but there also exists trade secret protection, where you have your examples like the formula for Coca-Cola or the secret recipe for KFC, and a lot of companies have their secret sauce that they don't release. Those all fall under the trade secrets. As a university, we just don't have the infrastructure to support trade secrets, and that's why we don't engage in them. But what we do a lot of is have a know-how, right? So that's specialized knowledge that all of you researchers develop on your various areas of expertise. It may or may not necessarily get up to the level of getting intellectual property protection, but it's still expertise in some shape or form, and that can be leveraged in different ways through consulting and advising and collaborations with other organizations. Right? So again, circling back to why technology transfer. So first of all, it's really not an optional practice for a university, and this stems from the Bayh-Dole Act. So the Bayh-Dole Act, which was enacted in 1980, it comes from the United States government, and it was passed to enable universities, nonprofit organizations, or small businesses to actually own or get title to their patents or their innovations and enable commercialization of these innovations, right? That were developed using federally funded dollars. So this act really goes a long way to motivate universities to become actively involved in moving their innovations from the research to external entities. And we want to get them into the market so that they can be actually utilized, right? It's no use if you have developed something super amazing, but then it just resides in the lab and isn't actually going there and doing things. So that was the main aim. In the past, before the Bayh-Dole Act, it was actually the government that retained title to the innovations that they funded. And that created a huge bottleneck because you can imagine the hundreds of thousands of innovations that are done by universities and other research institutions not being able to be evaluated or assessed appropriately and pushed to the market. So to overcome that and actually get these things out, the Bayh-Dole Act was put into place. A caveat of this is the fact that, well, you get federally funded dollars, you get to retain the title, but then you've got to tell the government what you've done with it, right? What innovations have you developed? And if you do have innovations that are eligible for patent protection, you're actually obligated to file on it, right? So if UNH as a university decides, hey, here's a cool innovation from CCOM, I want to retain title to it, the government's like, okay, sure, retain title, but now you've got to do something with it. You can't just keep it for yourself and not do anything. You've got to file for patent applications. You've got to show that you have made reasonable efforts towards commercialization. And that's actually done on a periodic basis. There are yearly reporting requirements which can be pretty specific based on the type of agency that funds you. So agencies like NOAA, which are really heavily involved with CCOM, have their own specific sets of guidelines on what they need in terms of reporting requirements, right? And I bring this up because, again, we're obligated to do this. And if we don't report or we underreport, we can get audited by NIST, which is the agency that's kind of responsible for overseeing compliance with the Bayh-Dole Act. So you can be audited, and it's not a good look for the university or any organization that's underreporting, because you're not telling the government what it federally mandated for you to do that. It was a condition of your grant, right? So not a good look and can potentially lead to loss of funding, current or in the future. So we've got to be really, really careful about this. But that's one aspect of it. There are also other reasons why technology transfer exists. And it's really there to ensure that the scientific and technological developments are accessible for either further development, for evaluation, protection, marketing, and also commercialization. So, we want to make sure that it's out there being used, it's out there being evaluated, which kind of gives more credence to the research that went into this and gives fidelity to the research. And it also fosters more engagement from other institutions or with industry partners and fosters collaborations, which are ripe for innovation and further development of ideas. Right? So it's a service to all the researchers at the university as well. And another small aspect of it is, if we do manage to license the intellectual property, the invention that was developed at UNH, there can be financial returns for the university as well as the innovator and the college or department that they're associated with. So that's a nice kind of return for your investment and your kind of effort and research in coming up with these innovations. And I like to think of it as an additional way for your research to create impact. I mean, coming from a research background as well, we all know the importance of having peer-reviewed publications and having your research impact qualitatively assessed in that way. But there's also this other aspect where your research can have tremendous amount of impact in terms of the problems that it solves and the people that it helps to do the things that they need to do. And to me, that's also a tremendous way of capturing impact of your research, which is not exclusive, and it's actually in addition to your publication record. So we work with you. We never stop you from publishing anything. That's not our mandate. We work with you and your publication deadlines to make sure that we can protect things adequately before they go out in the public domain. And I'll explain a little bit about what I mean by that in a second. So if you think you have something interesting that could be an innovation, please do reach out to us. I've put in some links and QR codes for our disclosure forms. They're pretty short. They're a page and a half, and it just gets the conversation going between you and us. And it helps us kind of get a quick idea about your innovation before we sort of have a one-on-one meeting to learn more about your innovation and how best we can support you. There are also policies in place at the system level from the University Systems of New Hampshire. So if you're interested in knowing kind of what your rights are, please feel free to check that out as well. If you have any questions about any of this, disclosure forms or the IP policy, please reach out to us and we'll be happy to answer questions about it as well. And once you do disclose an innovation to us, there are the innovators' Bill of Rights that sort of outline what happens, what are the timelines for different things, what happens once you disclose an innovation, and kind of what to expect. So please do visit our website, innovation.unh.edu. There's tons of information there, tons of resources that you can tap into as well. All right, so some of the ways that our office is actually engaged with CCOM that you may or may not be aware of is the CCOM Industrial Associates Program, which is a fabulous program and a fantastic way to engage with industry partners and have really constant influx of collaborations and new ideas. The way we get involved in this process is we help in the management and compliance of the partnership agreements. So anytime a new partner comes on or their membership needs to be renewed, you are required to comply with an industry partnership agreements that kind of sets the groundwork for how the relationship is going to be, so that there are no issues going down the line, right? We want to set the expectations from the very beginning in terms of how do you engage, what does CCOM provide to you, company, and company, what do you provide to CCOM? What are the rights in all of this, and how is IP managed, right? If any IP is generated. So we kind of handle all of that administrative work in the background, and any modifications or any negotiations that need to happen with the company to get those agreements executed are done by our office. So that's something that I'm heavily involved in. The other thing that we do, which I've spoken about a little bit, is managing the invention disclosures. So once you disclose an innovation to us, we carry out an in-depth assessment of the innovation from an IP perspective and from a commercialization perspective. And then we work with you to identify what the next best steps are to take that innovation forward, right? And that could result in patents, of which we have a number of them with researchers from CCOM. Some of the other interesting things we've done is also licensing. So you may or may not be aware, but there was this image of the Mariana Trench, which was actually licensed multiple times to different organizations, including Warner Brothers, for a movie. So sometimes really interesting deals can come out of the work that you do. You might not necessarily think that this would be the path that that particular piece of innovation or IP takes, but there's never a dull moment in the tech transfer office, I'll tell you that much. So kind of shifting gears a little bit and talking about AI tools. So artificial intelligence, really, it refers to a way of simulating human intelligence by computer systems, right? So there are a wide range of technologies that are covered by AI. And it enables a computer to perform certain tasks that were traditionally thought of as being done by human intelligence. And these can include forms of reasoning, some types of problem solving, a way to understand natural language, and also recognizing patterns, right? And this artificial intelligence isn't something that's just popped up, right? It's been around for a little bit of time. In fact, in the 50s is when the concept of AI began to take shape, where the term artificial intelligence was actually coined. And some of the earliest AI programs were developed around that time. Subsequently, in kind of the 70s and 80s, there was a lot of kind of growth and setbacks in AI, known as AI winters. And this was predominantly due to limited computational capabilities at that point. And also sometimes some really overly optimistic predictions. But then in the 90s and 2000s, there was a resurgence of AI, again, driven by the tremendous amount of increase in, the computational capabilities as well as the advent of the internet. And subsequently, that led to significant breakthroughs in things like deep learning and machine learning, which gave rise to some of the advanced AI models that we know now, such as GPT-3 and DALL-E, which have really characterized the last decade or so for us. But the last time I checked, which was a couple of days ago, there are really more than 300 tools that exist in the market for generative AI. And I'm going to separate out generative AI from traditional AI over here, because it kind of differs in its primary objectives and capabilities. So while traditional AI was designed more for data analysis and perhaps to make some predictions on, predefined rules and certain patterns, the generative AI has more of a creative aspect to it, and it can really create some new original content. And this can be via text, so using tools like ChatGPT and Bard. You can have images created using DALL-E, Stable Diffusion. There are tools that help with software like the GitHub Copilot. You can create videos or music, and the list goes on and on, right? So there's a lot out there. And if you would like to know more about UNH's stance on the use of generative AI for research purposes, there's a really nice guide that was put out by the Research and Integrity Services team. So please feel free to check it out. Again, if there are concerns about IP protection, which we'll go through in the rest of the presentation, please do reach out to us at Innovation. All right, so AI tools and intellectual property. So I'm going to start off with copyrights, because that's really a hot topic in the AI and IP space right now. So for a little bit of context, copyrights are there to protect original works of authorship, and what they need is for the author to fix the creative work in any form of tangible medium, right? So as soon as you do that, you automatically get copyright protection. You can go ahead and register for copyright protection. That's an added layer, and it provides a legal basis if you want to claim infringement by somebody. But as long as you fix something in tangible medium, so if I'm taking notes during this seminar, that piece of paper is now my copyright, because I have processed the information from the seminar and put it down on a tangible medium, which is that piece of paper, right? And copyright protection can be extended to lots of different things, such as paintings, photographs, illustrations, musical compositions, computer programs. The software is huge in the copyright space. There can be recordings, books, plays, lots of different things, okay? And the copyright protection, for the sake of simplicity, is extended for the lifetime of the author plus 70 years. There are some caveats associated with if it's a work for hire or if it's, if the author is not known. But for the most part, it's the lifetime of the author plus 70 years. That's a long time for copyright protection to exist. However, now looking at it from the AI perspective, there are a number of different issues that are associated with copyright protection in the age of AI. So one of the things that is required to get copyright protection is a creative expression by a human or a legal entity, right? If you don't have that, you don't get copyright protection. So an AI tool is not human. And so the attribution or the authorship of the copyright can't be given to the AI tool. So I'll give you an example of this, and I'm kind of jumping to the bottom of the slide right now, and we'll go through, circle back around. But there was this example of Zarya of the Dawn, which was a comic book that was filed for copyright protection. Now, the comic was the images in the comic were developed using Midjourney. And although the Copyright Office initially granted protection, that was because it was not disclosed that AI was used in the preparation of those images. When this was found out, the Copyright Office actually rescinded the the registration that was offered, and it altered it and justifying it in the way saying that, all right, the images themselves were generated by an AI tool. There was no human involvement in creating those images. Now you might argue and say that, okay, but there were prompts that were given. And the counter for that was really to say, well, that the prompt may not necessarily have given that specific image that was used in the book, right? You can give a prompt and that can lead to various different outcomes. The same prompt can have various different outcomes. So there isn't that human aspect of, hey, I thought of this, I created this, and this is the outcome of it. What they did grant copyright protection on was the text that went into the comic book, because that was generated by the author, and also the unique arrangement of the images, because that was, again, a creative aspect of the book that could be attributed to a human author. So a really interesting way to kind of think about it. So when we're thinking about outputs of AI and whether they can be copyrighted, there are caveats associated with it. But let's kind of circle back and think about the inputs, right? So these AI tools were developed by scraping the internet and lots of information, lots and lots of data that were subject to copyright protection. There were lots of photographs, there's lots of software, code, books, so many different things, music, all of these eligible for copyright protection. And all of these tools, all of these resources were used by the AI software to train itself, right? So that raises the question on, whether that's an appropriate use of the copyrighted material, or is that an infringement, right? Because you're using it without the copyright owner's permission. So there have been a lot of cases in the federal court about this. The New York Times filed a case against Meta because, again, there were a lot of articles from the New York Times that were scraped by Meta, and there were even examples of something that New York Times does, which is called Wirecutter, when they review certain products and services, and the AI would spit out these reviews just like Wirecutter would, but it wouldn't be of the same products, and it would be in the style of Wirecutter, so you're not sure what is what anymore. So there's that, which is still kind of ongoing, and we're waiting for the verdict. There's also Getty Images versus Stability AI, where Getty's suing them for scraping all of Getty's images and then generating like images. And this is actually an interesting one because this falls into sort of copyright infringement, because you're using Getty's images against itself, because the AI is now a competitor to Getty, and somebody could go to Stability and get that image instead of licensing it from Getty. So that's a direct competition. So they're using Getty's own products against them. And there's also a trademark aspect to it, which we'll go through in the next couple of slides. So there are lots of different aspects to think about over here, and also from the perspective of softwares, right, which is something that a lot of you deal with as well at CCOM. When you're scraping stuff from something like GitHub, there are licenses associated with codes many times, right, and that they require attribution. So when you get stuff from the AI tool, you're not sure whether you're actually infringing somebody else's rights, and you're not giving them the proper attribution when you're reusing their code. They might release it open source, but open source has a number of different licenses that you need to adhere to when you're using those products and services, right? So again, ever-evolving space, and it's dealt with on a case-to-case basis, but just something to be mindful of when you're thinking about using AI tools for copyright-based purposes, right? Now, thinking about patents, which is, again, something very applicable to your research here at CCOM, just to give you a little bit of a primer on patents. Patents really give the owner of the patent a limited monopoly. It's not a positive right, it's actually a negative right. So it doesn't give you the right to do something, it gives you the right to prevent others from doing something, right, with your innovation. And that could be you're preventing others from making, using, selling, offering to sell, or importing that innovation into the United States. So it's a interesting caveat to kind of think about, but just because you have a patent for something doesn't mean you have the right to practice that innovation, right? So patents are generally, the most common types of patents are utility patents, which are granted for 20 years, and that's the limited monopoly that's given to you. And this is really done so that it's a trade-off, right? When you apply for a patent, you are really giving away the exact instructions on how you are making or using that particular innovation. And because you have to really disclose everything, the government grants you that legal framework for 20 years to protect that innovation and prevent others from misusing it without giving you proper attribution or whatever consideration you desire from it. But it's not always easy to get a patent application. There are a number of criteria that are used to evaluate innovations to see whether they should be granted a patent. And the first one is pretty easy to overcome most of the times, in that you have to show that it's useful. So it actually does something. It's not a theory, or it's not a conceptual thing. It's not your perpetual motion machine that doesn't exist, will not exist, and isn't going to be useful. The next thing is that it's new or novel. So the idea is to foster innovation, to foster new ideas and encourage them to be shared. And so you want that idea to be new and novel. And the third bar is for it to be non-obvious, which is often quite hard to wrap your head around. And this is sort of where most things get stuck with the USPTO. But non-obvious is really what they're saying is, hey, you can't just combine publication A and publication B together and come up with your innovation. There has to be something inventive. You conceived of an idea and you put it into practice, and that added to that initial state of the art or whatever is known in that field. And for that intellectual contribution, for that enhancement, or that new way of doing things, you are granted a patent application, right? So when thinking again about patents and AI, there are a number of things to be considered here. Now, there are a lot of uses for AI when it comes to um, innovations. I mean, it's used to solve a lot of technological problems. You know, there are applications in drug discovery for creating new machines, so many different things that you could benefit with using AI for. But with the way the current legal framework stands and the way the legislation is outlined with the Patent and Trademark Office, there are really a lot of issues with protecting any kind of IP that is generated by AI. And this is highlighted by one of the cases between Stephen Thaler and the United States Patent and Trademark Office. So Thaler actually came up with a couple of, well, Thaler designed a system, the AI system, that came up with a couple of innovations. One was a fractal food container, and the other was a device and method for attracting attention, kind of like a beacon out at sea. But these were solely created by the AI tool, and there was no human contribution to it. And because that was the case, there was no IP protection granted. And Thaler actually applied for IP protection in a number of different jurisdictions. So, you know, UK, Australia, Japan, China, Korea, lots of different places. The only place that has granted a patent to Thaler is actually to South Africa and Saudi Arabia. But they have a very different way of patent evaluation than all these other jurisdictions do, in that the patent is not heavily scrutinized up until there is somebody that's claiming infringement of some sort, right? And then that's when, so it's more of a repository, and the patents are then subsequently analyzed. So Thaler actually sued the USPTO, saying, well, this is not right, and you should consider AI as an author. And this decision was actually upheld in a lot of district courts, and also the Supreme Court declined to hear Thaler's argument, so they upheld the decision that was made by the United States Patent Office. So while artificial intelligence has been used for a long time in many of these aspects, in creating machines and creating new drugs, where there is no human involvement, it's going to be you're not really going to get patent protection granted as things stand right now. Right now, there could be instances where the AI is used as a tool, just like you would, you know, modify an image using Photoshop, where Photoshop is really the tool, but then you are actually doing the work and the modification and thinking and creating it as you go along. Same way AI can be used as a tool as well. You know, let's say in drug discovery, for example, it can spit out hundreds of targets, and then you as a human need to pick and choose and test and modify and figure out how to actually produce these things. And so there's a significant amount of human involvement in the process of going from lots of randomized compounds to the one that makes it, right? So in those cases, IP protection is possible. But it's really, really evolving and changing. And you've got to be proactive in defining the line and saying, right, this is what the AI generated. This is where the human aspects were, because those will be scrutinized and questioned. In that vein, there are actually going to be some guidelines that are released by the United States Patent and Trademark Office towards the end of this month. So we're all, looking out for those and seeing how they impact how we think about the use of AI in patentable inventions. And lastly, I want to touch a little bit upon trademarks. So the primary use for a trademark is really to identify your goods and service. So it could be any word, phrase, symbol, design, or a combination of these things. And the thing that you need to do is you need to demonstrate how you are using the trademark, for what purpose, and the fact that it's actually in use. So, it's used in commerce. So you have to demonstrate that, right? You traded with it, somebody bought that good or service. The good thing about trademarks is it can last forever, as long as you keep renewing them in every 10-year intervals in the United States. And to do those renewals, you have to demonstrate use, but as long as you keep doing that, trademark is valid. But again, thinking about AI and trademark, so I'll go back to the Getty example. If you can see, the image on the left is what was actually on Getty, but then the image on the right was one that was spit out by a generative AI model. And you can see that Getty has a case for suing Stability AI because it's saying, well, you've clearly scraped our material. And that's proven by the fact that the AI considered the watermark for Getty images to be part of that image, and in a weird, distorted form, still reproduced that watermark. And in the trademark sense of it, that can be misleading because somebody could think that this is actually from the Getty Images website when it isn't, and it tarnishes their brand, right? So again, lots of caveats there, lots of issues. But just something to bear in mind about AI and trademarks as well, and brand dilution. So thinking about our current challenges and opportunities that exist with using AI tools, as you may have realized during the talk, it's really a rapidly evolving field right now. But one thing that I do want to put emphasis on is saying that the use of generative AI in research may lead to loss of IP rights. And I say that because when you have something innovative that's not known in the public domain, putting it in an AI tool essentially releases it in the public domain. And once something is out in the public domain, you can lose rights. So especially for patent eligible subject matter, as soon as you make a public disclosure, and public disclosure can be in many different ways. It can be if you present a talk somewhere, if you put out a poster, if you, if you release something on a blog. Of course, your publications count as public disclosure as well. So all of these lead to immediate loss of international rights. In the US, you have a grace period for 1 year, but ideally you want to have protection before doing any public disclosure as well. So just something to bear in mind when you're thinking about using AI tools for and putting your confidential research in it. Just please keep that in mind. There are instances where tools are hosted within the institution, so they have their own instance. And in those cases, the conversation varies slightly because you're not putting it out there in the public domain. It resides within your organization. But that not being the case, essentially it's just out there and you've lost your rights. Right? So talked about public disclosure. The other thing to consider as well is, what about the data, right? So already we've considered the data that you put in. But what about a prompt that you put in and the data that it's scraped that is being used to provide a specific output to you? We considered the implications of copyright infringement because you just don't know the source of the data. So there can be issues of liability that come in of infringements. What are the rights that you're not affording to the author of that copyrighted piece of information? So lots of different things to consider there too. So just to kind of capture a number of different challenges, there are ownership issues that come up with IP generated through AI all the time, right? You've got to outweigh what's the benefit of using that AI tool for your research versus what's the risk of actually not getting IP protection. So, there can be cases where you're like, okay, there is this specific compound that I developed or the specific machine that I developed using AI. I can't obviously get patent protection for it. A company is unlikely to license it because a competitor can just take it and copy it. And why would anybody give me anything for that? Right? So something to think about when an invention is purely designed just by an AI tool. There are also ethical considerations, right? There can be bias depending on the type of data that was used to train the AI model. Issues of privacy, right? Do the Meta AI scan billions of photographs on Facebook and Instagram to train its AI? What kind of privacy concerns does that create? Whatever information was used to to use the AI train the AI model, can it be misused in some ways? People did not necessarily provide consent to using their personal information for these training purposes, right? So lots of privacy issues there. And there could be security concerns as well. We've all heard of the hallucinations that happen with using AI tools. So can you really trust what it spits out? Doesn't give you this many of the models don't necessarily give you the source of the information. So how do you know what it's saying is actually accurate, right? And the other aspect of it is also, how do you incentivize the right behavior without locking up inventions? And there are clearly benefits of using AI, but if the whole patent system, for example, was created to incentivize innovation and to create collaborations and to speed up the rate of innovations, and you can kind of see that as well. But with AI, that's not an inventor. How do you continue that? How do you incentivize people to just keep on innovating without necessarily having the legal framework to protect their innovations, right? And this is kind of a tangential point, but it's sort of actively in play at the moment as well. There's an international component to it because, again, the IP protection is very geographically separate. So each jurisdiction has its own way of evaluating intellectual property protection rights. And for the most part, there is homogeny in the way these things are assessed. But as we saw with the example of the Thaler case, the patent office in South Africa did grant a patent to an AI author. So that can create maybe certain pockets where AI-powered tools or innovations are more incentivized, and it could lead to conditions where the IP powerhouses, such as the United States, kind of start losing their edge because companies move away to these other pockets, right? Having said challenges, everything is not grim and gray. There are a lot of opportunities as well. AI can certainly help accelerate the rate of innovation. I mean, the processing power is just unparalleled, so you cannot, no human can compete with that. So there's obviously that massive, massive advantage to look at. There's also the possibility to augment current jobs, right? That could potentially be deemed unsafe or dangerous for humans to do. And machines kind of take those over. And if they can be AI assisted, it's even better, right? There are also cases where AI can assist with IP management and strategy. So, some of the things that organizations routinely do is when you're looking at your IP portfolio, you want to see, well, what are the trends in the market? What's your competitive landscape? Who else is out there in the field? All the things that you do to carry out your in-depth IP assessment or due diligence to see, hey, is this something that I should pursue further? Right? So AI can kind of help scan all of that information and process all of that to provide you with data that you can then use to make that determination and evaluation of how to handle your IP portfolio. And the other side of it is also there's the IP enforcement piece, right? So imagine having to go through different websites trying to scan, hey, does somebody have my copyrighted material? Somebody is using my trademark. It's very, very labor intensive, but with an AI tool, can be done in no time on a continuous basis. And you can actually keep better track of your copyright or trademark portfolio by automating the detection of these infringement cases. I apologize for the typo there. The top line should be there on that slide. But I think the main things I kind of want to have to focus on is that it's really very, very current. It's an evolving conversation right now. There are lots of different things in place. So in terms of governance, there was an executive order that was put out from the current administration to promote the safe, secure, trustworthy development and use of artificial intelligence. And that's the mandate that all of these different agencies have been given. And they need to come up with their own guidance and procedures on how to do that. But it's changing, it's evolving. And as AI becomes more ubiquitous, it's going to be harder and harder to delineate, well, what was actually done by a human and what was actually done by the AI tool, right? There are also lots of legal caveats. As I said, there are so many cases that are pending in the courts right now. And the intersection of AI and IP really necessitates a nuanced legal framework. And it actually poses a lot of complex challenges. So everyone's kind of learning as they go along, and it's changing on a daily basis. But they are continuously trying to address the complexities and ensure that there is responsible and accountable adoption of the AI tools. Similarly, in terms of intellectual property, there are actually certain companies, such as Microsoft, OpenAI, and AWS, that have announced plans to indemnify their customers from infringement lawsuits that come out of using their AI tools. Having said that, they don't necessarily always cover what you think they're going to cover. It's not clear at all. They haven't been described. in any shape or form. So it may not necessarily afford you the protection that you think it affords you, and the companies are not willing to disclose the specifics of their indemnification policies right now for obvious reasons. So it's just something to keep in mind. Just because they say they're going to indemnify you, you don't know the fine print there. So my kind of advice overall would really be tread with extreme caution. And if you're in doubt of any sort, please just do reach out. We're here to help. We're a resource. We try to keep up with the latest regulations that surround this space and can provide guidance, or at least point you in the right direction to get more information. So do please reach out to us. We're learning just as you are about the field, and we'll try to help you as much as we possibly can. And with that, I would like to thank you all for being here, and I'll open the floor up to questions.
Do we have questions?
I have a question.
Yes, go ahead, Bob.
Hi, thank you for this. It's super helpful.
Glad.
I guess one question I have is with regard to large language models and that version of sort of generative AI, and realizing the risks that you've well pointed out in using something like that in terms of the validity of the answers it gives you. But we're thinking of using it to understand natural language questions and provide answers that we can more easily, how do I put it, like more easily take action on with a robotic system. So kind of translating it, like using the breadth of knowledge, if you will, that a large language model has to answer a complex question that would allow us to make an easy robotics decision, in this case, for steering a boat. So in that case, we're not doing generative AI like to build a product or a picture or something like that. Do you have a sense of what the university's guidance would be in that regard? I mean, part of the research would be understanding how well it can do that and whether or not it gives you consistent answers and all the kinds of things that you warned us about just a moment ago. So I understand that bit, but the rest of it I'm curious about.
Yeah, I think, and if I understand it correctly, please correct me if I'm wrong as well, but you're actually using the output to understand how the complexities work and kind of use the output to test something with, how the boat steers, or how, what are the different options available to you and what works best.
It'd be like we would ask the large language model, should I turn right or should I turn left in this situation? And then it would give us a response, and we would try to execute that response.
But then you would analyze that response and see whether it was the right response or wrong, and then
To start, but if we felt like it was giving us the right answer all the time, then we might just believe it and use it operationally. That would be the goal.
right. And I think, I mean, again, it's involving, but so the university doesn't have, because it's changing so much, it's hard to say in black and white, and that's why it's always on a case by case basis, because it's really hard to just sort of have a blanket statement saying, right, for this purpose, sure, for this purpose, not really. To me, it seems like there is a lot of testing and a lot of evaluation involved before you sort of unleash it and say, right, the board is just going to do exactly what the LLM dictates it to do. And there is that human testing and human aspect involved. The extent to which you test it is, again, I leave that to you. But in terms of IP, it just depends on how much of the model it is that you use. Is it, how do I say this? Is that code going to be what's going to be used on the boat going forward? And if so, the question or the caveat is, well, how did the model generate that code? Is it infringing on somebody's existing code that they released open source? That's my caveat with it. But in terms of actually using it to do the steering or provide the next command, if it works, great.
Okay, thank you.
Sure.
Yeah, I might just have a follow-up on that. I think what you're saying, Val, maybe you're taking a model that's open source, you're just taking the weights from an already trained model, and just you doing the inference on your own hardware. If that's an open source model, it's kind of not really that much different than just using a module of another software package and integrating it with your system. I don't know that that's too different, and maybe that's okay. Again, it's case by case. I know what I've played with these things a little bit, not really much for, is just to see what they can do, is generating test data, for example. So it's even more removed from what you're actually doing. Just say, hey, I need a bunch of dates in this format from this range in this time period. Give me 100 or 1,000 of them, and spit it out. That kind of thing. So just to add a little.
But
Yeah,
like,
and I think that's a really good use for this, right? Because you could compute it, you could write a piece of code that does the same thing, but then you're just getting that step out of the way and using the AI tool to give you that data set to use for whatever purpose you might. And that's a good and safe use of the tool, and it speeds up your research process. Don't see any issues with that.
Val,
oh, I was just thinking about so if you're generating test data, for example, I'll use yours as an example. Maybe the model that you're using to generate that test data has been quote unquote released in the public domain, but is based on copyrighted data. Maybe it's from images that were copyrighted, or from text from the New York Times or whatever. And so I don't know how to think about that exactly, and whether or not that's something that we need to worry about, or if that's on the shoulders of the people who released that model initially.
You can't generally protect data. You can protect the representation of the data. Like, you can protect the phone book, but not the numbers, is the classic example. Right? The phone numbers themselves are not copyrightable, the phone book is. So data that was generated probably would be okay, I suspect.
But if it's art or somebody's written work and
That's-
it's just shutting it
that
out, that is
yeah.
copyrighted, and if there's just
Yeah.
shutting that out, then you're in trouble. But if it's
Oh,
just
the question is
dates
who's
information,
copyright?
that's different, so.
Right, but the question is whose copyright?
Yeah.
Because it could be multiple people's different copyrights that are mushed together somewhere in the network. So it's not clear who owns it, if anybody. And I guess that's an auxiliary question as well, is if we were to be cavalier enough to install GitHub Copilot, and you use it to generate a framework for your project, which you then go on and finish by hand, is the whole project's IP tainted by the fact that part of it was automatically generated? If you keep the automatically generated part separate and declare it separately, does that protect you? Or is this something where we just don't know?
The separation protects you for sure. If you can show clearly, there is part A, which was done by the GitHub Copilot, but then there's part B to it, which was just purely with human. The part B can be protected, I'm assuming it's copyright protection, that can be afforded to you because there's a clear delineation. Where it's not clear, you are required to provide evidence. And then that kind of gets into really fuzzy waters as well.
So
in
the
terms of-
question is whether as the saying goes, the juice is worth the squeeze. If the benefit of having the automatically generated code is sufficiently high to warrant looking after that distinction, so you can make that demonstration.
Did you repeat that?
Yeah, oh, sorry, I was thinking out loud. So the question is whether the value of the automatically generated code is worth the cost of looking after the documentation, so you can demonstrate that you have carefully divided the bit that was automatically generated and can't be protected, and the piece that was generated by you and can be protected. Because there's a lot of paperwork involved in doing that, and a lot of careful, methodical work involved in doing that. You have to ask yourself whether what you gain from the automatically generated part is sufficiently valuable to make it worthwhile to do all that extra work.
Absolutely. And that goes back to that risk versus reward analysis as well, right? Is it worth it to maybe lose IP rights for the benefit of generating something or accelerating that generation by a number of years using the AI tool, which it wouldn't have otherwise? Again, that depends on a case-by-case basis, but it does warrant some evaluation.
I think that's it.
And I have another question, if that's
Okay,
okay.
Stephen.
So imagine that we build an AI tool from data sets that we collect, and some of those data sets are copyrighted by other folks. So I should be careful because Brian says you can't copyright a data set, but so I mean, so in this case it's images. They're images that are in the public domain, I'll say, like they're maybe off the internet. So we don't really know what their copyright status is. Presumably every one of them is copywritten in some way, just like everyone else has done. And then, so what can we do with that, I guess? Like, are we able to make a tool that maybe can, in our case, detect buoys? And then own the intellectual property rights of that tool after the fact, even though it's based on, like we built the tool, we trained the model, all of that kind of stuff, but we did it with data that was in the public domain, if you will. But does this make sense?
It does. And that's the question that a lot of these AI tool companies are grappling with as well, because there was a lot of use of things that were in the public domain that were used to train these AI models. And what are the implications of this? We're just not there yet in terms of how to think about it. So this is a more watch this space kind of question, because the legal framework just hasn't established that far yet. So you're not the only one in this space, but we just don't know at this point how the regulations are going to weigh, whether this is going to. There is a caveat in copyright law that allows for fair use. So in that space, you can use copyright protected material for certain purposes. For educational and research use is one of those fair use arguments, right? Now, if you go ahead and commercialize and monetize that tool, that strays a little away from the research and educational purpose use. So the fair use argument has been used in copyright protected material. I think in your particular case, it may be more applicable than not. So I think you are safer than companies like OpenAI and Meta that really monetize their AI tools for public use. You're really using it for research and educational purposes, which may fall under a fair use argument for using of copyrighted materials.
If we wanted to license it to one of our industrial partners afterwards, we may then run into difficulties at that stage.
Potentially, yes.
Yeah, even if the images are Creative Commons, sometimes those require attribution, and if you can't,
They do.
I guess you just, it'd be like, if you actually look at the fine print of your operating system, there's all kinds of licenses listed, like my university I went to is listed, you know, as a licensee, licensor. So you have to just list everybody.
Pretty much. Pretty much.
And which means you have to track it, which is another thing.
Which, if you were writing a paper and you were using all that data, you would be citing it. If you were doing your job, you'd be citing that you used the following data sets to come up with your results. And if you
If
put
you can.
pages in the figure, you know, I mean, if you knew where you got the data from, right? You should be tracking where you get.
No, yeah, but you might not, or you might not be able to positively attribute every single bit that you use.
So that
And
would
then
be the
question
caveat,
is your
if you
entire,
can't do
is your
that.
entire model tainted by one poisoned apple?
So if you can't track it, then that poses a problem.
Yes. Because you can't track, you can't provide the attributions that may have been requested, depending on the type of, say, Creative Commons license that was granted on that image, or whatever copyright attributions it required. And if you don't do that, you are not following the mandate and so are infringing.
It would be helpful if the, I'm gonna regret asking this.
It's never stopped you before.
It would be helpful if the university could generate a policy and a statement and a license even that says for things, for artificial intelligence gadgets, gizmos that rely on copyrighted material under the fair use argument for research, we are going to release the results of those under a license that is open for fair use as well, but not maybe for commercial applications. If that's the right thing to do, so that we could then turn around, like we could train something or build something and at least put it into the public domain in a way that other people can freely use it. They just can't sell it, if that's the restriction that the copyright, law requires. It'd be nice to have something like that.
Is there a contingency in the copyright law if you are undermining somebody's right to make a profit from their copyright by basically kind of reworking their proprietary product?
They can be if they're in the same space, and the argument becomes stronger if they're in the same space. So in the case of Getty and Stability, because they were competing for the same customer, essentially, there was a stronger case for, hey, you owe me damages because that's revenue that I could have made otherwise, and you're taking it away from me. So in certain cases, yeah, there's a reason, there's enough evidence to show that the infringement actually had consequences for the originator.
Everyone happy?
You don't want to make people put their data behind a paywall.
We're
Prevent you from doing
having
that.
fun now. Thank you so
That's where
much
I'm going
for
with
doing
that.
Thank you so much for being here today. And that's it, guys. Thank you so much.
Thank you.